position of precedent in India. The doctrine of judicial precedent got recognition in India under Section 212 of Government of India Act 1935. The decisions of Federal Court and Privy Council were binding over all the subordinate or inferior courts in India as per the provision of this section under the Indian Government of India Act 1935. After the enactment of the Constitution of India, Article 141 of Indian Constitution have declared that every decision of the Supreme Court of India is binding over all the inferior or subordinate courts in India. In the most important leading case, Dwarika Das Srinivas versus Solapur Spinning and Weaving Company Limited of 1954, Justice S.R. Das expressed that Supreme Court is not bound by its own previous decision. But this was again a question before the apex judiciary. In Bengal Immunity Company Limited versus the state of Bihar in 1955, where their lordship expressed that the Supreme Court can override its own previous decision, and the tradition was substantially changed, and this tradition was again substantiated in the famous leading case Goloknath versus State of Punjab in 1967. In that case, the apex court and their lordship overruled the previous decisions of the Shankari Prasad versus Union of India 1951 and Sajjan Singh versus State of Rajasthan of 1965. So, the Supreme Court of India is empowered to overrule its own previous decision after this famous decision of Goloknath versus the state of Punjab. And the very controversial article which was in question in several leading cases was Article 13 and Article 368. So, in those cases, or in particularly in Goloknath versus State of Punjab, it was pronounced that the very Article 13 and Article 368 of the Constitution does not provide the constituent power to the Parliament of India. So the Parliament of India could not exercise the constitutional amendment power on the basis of the provisions of Article 368 and Article 13. So also another important decision, that was the fundamental right case or the Keswananda versus State of Kerala in 1973, their lordship overruled the decision of Goloknath case. So, again, the Supreme Court overruled its own decision in the important fundamental right case Kesavananda Bharati versus State of Kerala in 1973. And now the question is that the position of precedent in Indian judicial system. So all the high courts existing in every state are completely bound to follow the previous decisions settled by the apex court or the Supreme Court. In the same way, all the district sessions courts or subordinate courts in India are bound to the decisions or previous decisions settled by the High Court or Supreme Court. In the same way, all the magistrate courts and municipal courts, which are in the inferior judicial system in India, are bound by every previous decisions delivered by district sessions court, high court or Supreme Court while administrating justice. So this is the position of precedent in Indian legal system to be followed by Indian lawyers, judges, advocates and counsels.